I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial daddy.
I want to give a big shout out to the 13th Jury Podcast and Brandy.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
And then I just look to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, want some coffee?
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Good morning. Hello, friends. Hello, family. Hello, jurors. Hello. Good morning. Let me know if my mic is too hot because I've been recording the podcast. And a lot of times when I'm recording the podcast, then I come on here and you're like, oh my God, my ears. So if it's too loud, let me know. I am glad to see y'all this morning. We have a full day. Gonna get wild. Oh, it's a little low. Oh, I overdid it this time. Normally it's too loud. So I was like, you know what? I'm gonna go ahead and crank it down. Let me know if that's better. We'll figure it out. We'll do it as we go. It is going to be a full throw today, as Mr. Jackson would say. A full throw today. The dogs are already snoring. That's a good sign, right? Is that a good sign? It's a good sign. We'll say it's a good sign. Oh, yes. Regina, how many times are we going to hear the word methodology? Let's do a poll. We need Marie Moss to count for us. How many times will we hear the word methodology today? Okay, let's do 0 to 5 will be our first option. Okay, 6 to 10. No, let's go a little bit more narrow. We'll do 0 to 3 is our first option. And we'll do 4 to 7 as the second one, 8 till 11, okay, starting the poll. There's the poll. All right, so we've got that going. My vote is for D, but I'm just throwing that out there. We are probably going to hear it a whole lot, a whole lot. That happens. All right. Oh, y'all are still saying it's low. Let me. Okay, how's that? Is that better? Do you want me to whisper? Now I'm scared I'm going to blow your ears out. Just yell, hey, y'all. What's up, y'all? Y'all hear methodology? Just joking. I am glad to see you all. I am looking forward to today. It's going to be a big day. Now, who in here, by a show of hands, emoji hands, there's like a little emoji for that. Who in here, by a show of hands, has listened to the latest podcast? Because a lot of what we're going to be witnessing today is from the motions that were filed that I went over in the podcast. So I love seeing the pink hands. Love it. You listened. Good. A lot of what we're going to be hearing today is going to be stuff that I went over and kind of broke down in the podcast. Now, there are some things, look, y'all, I get it. There are some things that a bunch of people were emailing me and messaging me and DMing me and sending carrier pigeons and whatnot. However you try to get in touch with me, I get it. There are a lot of things that people were seeing that they were very frustrated about in some of the last hearings that they were saying were a huge deal. A lot of them I agree with. Some of them I think we need to hold off on our jumping to, we like to leap, but we want to hold off on leaping, hold off on jumping to any kind of conclusions, because there are some things that I saw that y'all were messaging me that I don't think yet that it's time for us to panic over. One of them, I got a lot of people, y'all were sending me stuff about Paul O'Keefe being there for the testing. For me personally, that part wasn't as big of a deal to me yet. I want to hear more about it, but that part wasn't as big of a deal to me yet as the part about them not letting the defense know that they were testing. I think that for me, and I went over this in the podcast, I think for me, that was the bigger part for me, because, and I had a bunch of y'all asking me this. I wish I had time to answer all of your questions and emails and all that stuff that I get. I really do try, but if y'all, it's been crazy, and I've been trying to make sure I take weekends off. I didn't this past weekend. I did take Sunday off because I went to the races, but I worked. Anyway, so I have tried to answer as much as I can, but I just can't get to them all. So I will answer what I can while we're here. The one about his brother being there, y'all keep in mind that the Commonwealth is not in possession of John O'Keefe's car. So it is more than likely in the care of his brother or his mom, and dad, I would assume. That is just me assuming, which we're not supposed to do here, but look at me just over here assuming. But I would assume that is the reason that he was there. He would have had to have given them access to it. So I'm not going to panic on that yet. I want to see more details about that and see what they say. But to me, the bigger part of that is they didn't tell the defense that they were doing the testing. Now, keep in mind, if you are going to do some kind of testing on something and then present it as a report, it would make sense to let them know that that you're going to be doing that testing, because look at how they're doing with the whole Arca thing. They're like, oh no, they're doing all this, and how are we supposed to cross-examine because we don't know anything about how they did all this. Okay, well, it's kind of like if the defense isn't able to get access to the car and the driveway to do their own testing, how are they going to be able to, have their own cross-examination prepared and all that stuff? So I think that they should have told them. As far as like a legal requirement, I reckon it's not a legal requirement, but Hank Brennan, Mr. I'm so transparent and I do. Oh, and that's another thing. If y'all listen to the last episode, I'm aware that I didn't filter out my snark, and normally I do. But also I don't really have to, because this is how I feel. We're past the point of, we are now, 38 episodes into this podcast, right? 38 episodes, like one full trial, at least 3 mental breakdowns. We're past the point of me going into this waiting to see the evidence. We've seen the evidence and we've seen what they're doing. I have opinions. I have very strong opinions on certain things, and I am going to release the snark that I feel in my bones, because that's where we're at emotionally, mentally, and spiritually today in this moment. So if you noticed in the last podcast that I did get a little snarky, it's because I don't like Brennan. I don't like Brennan. I think he's dirty. I don't like the way that he does things. I think that he is much more interested in getting a win as opposed to seeking justice. And bro, your one job as a prosecutor is to seek the truth, not to seek a conviction. But, what do I know? I'm just some, chick on YouTube with a podcast. So I don't like him. I'm not going to pretend like I do because it's like politically correct thing. No, I don't like him. I think he's a douche. I don't like him. He is going through this whole thing of like, I am just so transparent and in the pursuit of, justice. I just want to be transparent. No, you don't, sir. Sit down. No, you don't. That is not what you want. That is not how you're behaving. So, I did get a little snarky. It will probably get worse as time goes by, but we're going to see how it goes. Maybe it'll change. People change. Brennan's probably not one of them, but we're going to see. We're going to wait and see. So I did break down all of the stuff that's going to, a lot of the stuff that we're going to be hearing today. I did break that down in the last episode, and there was a lot of snark. There was a lot of snark. But I'm not happy. I'm not happy about the way that they've done things, and that's very obvious. Real quick, let's get to these. Regina Crawford, member for 20 whole months. Regina Crawford, love my 13th Sheriff family. We love you too, Regina Crawford. We love you. Lynn Trexler, member for 14 whole months. Good morning, all. Good morning to you, Lynn. Hello, Denise. It is good to see you. Member for 21 whole months. Good morning, Juror family. So glad to be here. We are glad to have you, Denise. We are glad to have you. Missy Russell. Hello, Missy Russell. Member for 14 whole months. Fan reunion that I look forward to. Yes. Yes. Love it. That's not a hippie. That's not a hippie. Member for 12 whole months. That's 1 whole year. Thank you, Brandon, for making this channel home. Oh, I'm glad that you're home here. Marie Moss, I just said we needed you. Marie Moss, our official statistician, member for 17 whole months, reporting for duty. Yes, we need you to count the methodology today. How many times do they say methodology? We need to know. Inquiring minds. Happy memberversary. Lady Patches, member for 20 whole months. Lady Patches, hello, my friend, hello. Yes, I'm ready. We are ready too. We are ready. Jackie D, hello. Jackie D, member 18 whole months. Hey, 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 everybody, it's my anniversary. It's my anniversary. I don't have my sound bites here at Chat Daddy's office that he made me, but we're going to work on that. Lori Jean became a member. Hello, Lori Jean. Hello, 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 hello. I'm glad to see y'all. Chrissy Robinson, I can't stand Brennan. Me neither. Me neither. Me neither. Oh, I get mad. I was sitting out here. So we had some of Chat Daddy's friends from Washington were here over the weekend, and we were sitting out there talking, and they have heard of the case. So I was sitting out there talking to them about it, and just talking about it, I get so fired up, and I'm like, so it was nice to have people who are like, they're not in this whole, like, YouTube thing, but they, have followed or not have followed it really, but just have heard of it and have, seen different things on it and stuff. So I was talking to them about it, and I was like, so hearing people who are they're not in this in social media or YouTube. They're, like regular, real people. Not that we're not real people, but you know where I'm going with this. So it was nice to hear their perception of it, because they were looking at things the same way. We were like side-eyeing the evidence and the investigation and all that. And I'm like, see, we're not crazy. We're not crazy. Hello. They're regular. I don't even know what that is anymore. But that's okay. Let's see. I watched the Lawyer covering the juror interview. Super frustrating. What can the defense do when the jury makes a lot of assumptions and thinks the defense is... So let me tell you, I haven't watched Peter's take on it, but I did watch the interview, and I asked Turtle Boy if I could use some clips from it, and he said, that's fine, use whatever. So there will be I am going to play some clips there that will be in the next episode. I was actually working on that this morning and yesterday. I have some thoughts. I have been very clear before about how I think that jurors go into this, with almost like this sense of duty of being a part of the justice system. And I think that sometimes the presumption of innocence kind of gets overshadowed by the sense of, I remember the juror said something at one point about, wanting closure, like for the family and stuff. And I was like, I was like, yeah, see, that's the thing. It's like we're so programmed to want that from, TV movies, like, like cheering for the, good guys to get the bad guys. I think that we're so, that's so ingrained in us that we want that it kind of becomes almost not more important than the presumption of innocence, but I think that subconsciously people feel that that's more in your, in the front of your mind than the presumption of innocence. I think that people don't go in there like, this person's innocent, prove me wrong. I don't think they do that. I think they go in as like, they got the guy, now they just have to prove it. But you're not really having to prove it. You're having to, it's hard to watch because I do understand why it happens, but that's part of the reason that makes, part of the reason that a jury trial is so scary, because think about how many juror interviews you've seen where they're like, oh, I could tell it in their eyes. No, sir. No, ma'am. That is not evidence. You cannot tell it in your eyes. I make the weirdest faces. If people screenshot my stuff, and I'm sure they do. I'm sure there's, shit all over the internet of me making weird faces. I'm okay with that today. I could give two craps. But if people went by just that, like weird faces that I make, I'd be screwed. Like you'd convict me in a heartbeat. I could be on the other side of the world when something happened. But if you're going by my faces, I make weird faces. It's just who I am as a person, and that's okay. You can't go by that. You can't go by, oh, he looked like my ex and my ex's trouble, so bam, guilty. You can't go by, he didn't show remorse. If you're not guilty, you're not going to show remorse. Like there are certain things that I think that jurors will base their decisions on, and you can't do that. And that's what makes a jury so scary, because they are so unpredictable in that sense. And I think that it's interesting to see what all is being said by this juror and in other juror interviews as well. But I think that with everything happening in this case, especially with this juror confirming that they had all agreed on the not guilty for the murder charge, I think that this is going to be a huge, like one of those milestone cases that changes the way that everything's done forever. So hopefully, anyway, because Lord knows it needs to be changed, but we'll see. Because I'm very expressive. I am very, very expressive. Yeah. Yeah. But, that's all right. All right. So let's see. Let me get our stuff pulled up. We'll do like a quick Cliff's Notes version of, oh yeah, good point. This is a very good point. If you can't presume a person innocent, then at least be honest about it. That's how the system works properly. That is absolutely true, because I know that some people, and I know some of those people, there are some people who have never once thought that a defendant is innocent. And I think that is just how some people are. And I get it. That's fine if you are like that. But it's only fine if you are like that if you are honest about the fact that you are like that. Because if you go into a trial and you're like, no, I can follow the Constitution and I can be, fair and impartial, and I can give the presumption of innocence. If you go in and say that knowing dang well that anybody who has ever been charged has always been guilty in your mind, that's a problem. That's how the system, that's how you avoid the system working properly. So that's a very good point. I don't hold the people who can't do that, I don't hold them like, I ain't gonna be mad at y'all if that's who you are as a person. But also, if that's who you are as a person, maybe don't like hide that when you're in jury selection, and also don't be a jackass on the internet about it. Those are just my two suggestions for you and going forward in life. That's just just throwing ideas out there. All right. let's see. Let me get the, oops, I just hit the wrong button. Stop hitting buttons, Brandy. Come on. Oops. I just literally did the wrong thing again. I hit the wrong button twice in a row. Oh yeah, I can end the poll. Here, end poll. Okay. All right. My money is on 20 plus times. It would not surprise me at this point in my life, I'll be honest. Oh, did y'all see the Robert Devine post-commission hearing? I put the link up before. Oh, hello. Hello, Dreamfeed Media. Hello. Hearts back to you too. I put the link up for Mizzy streamed it this morning for the post-commission hearing for Robert Devine. He was I think the next one's going to be March 18th-ish. Don't quote me on that. But it's basically kind of like kicking the can down the road. Not a whole lot. What is happening right now? Every time I click on what I think I'm supposed to be clicking on, it takes me to the Super Bowl halftime show. Why am I clicking on, what am I doing wrong here? Oh, there it goes. Okay. Somehow Karen Reed turned into Give Me a Hug Drake. What has happened? I don't know. Anyway, we've got it now. Everything's fine. Everything's fine. Oh, I gotta turn on my fan. Good morning. Good morning. Okay, let me share. Let me boost our volume too, because I think that their volume is not usually how I like my volume, all loud and stuff. All right, share screen. See, look, it went to Give Me a Hug Drake. Do you see that? I don't know why. Oh, no, that's one-sided. Hold on, I can't do one-sided. That's only in my left ear, and I hate when it's only in my left ear. Let me try another feed real quick. Hold on. I can't handle it only in one ear. Yeah, I don't even know why. Give me a hug. I have no clue. No clue what that means. No clue. That's okay. Oh, the other one hasn't started yet. All right, we'll listen to the one-sided. Oops. Okay, let's see. It's still only in one ear, so we'll see if... That's going to drive me crazy. Let me just mute this for a minute. Let's see. Dogs are getting mad at something. Nope, that one's it too. We got OnlyFan back. We got our OnlyFan back. It's the most exciting thing ever. I have to see. Nope. My computer's doing something really weird. All right, let me unmute this. While we're watching OnlyFan. Okay, Fangate. We're gonna see.
You gonna be speaking today? There's a lot to cover. Yeah.
I hear Turtle Boy. I said that and they muted it. Hopefully we'll get one that doesn't only have left. Yeah, the CC is always entertaining because it's never right. But that's okay. All right, so let's see. All right, so some of the stuff that they're going over today, there's going to be quite a few motions. Let me pull it up. Only thing gives it some rhythm. I like it. I like it. All right, let's see. Karen Reed. There we go. My folders are going like nuts right now. All right. So the motion to exclude Arca. So let's talk about that. Hello, Glare. Hello. Hello, my friend. We have audio again. Eavesdrop again. The motion to exclude Arca. I don't think that this is going to work. I think that if they actually exclude Arca, I think that there will be riots in the streets of everywhere. Okay, maybe not. Maybe that's a little bit dramatic, but I don't think they're going to be able to do it. That's exculpatory evidence. That's from a third party independent. And I get that they can't go through the whole process of, you know, the discovery violations and all that because it's federal. I get it. I get it. I get it. However, the way that they went about that last time was doing a voir dire, and I think that that's what they're going to do again this time. I cannot possibly see them, the court, aka Anti-Bev, saying, you know what, we're just going to exclude that exculpatory evidence because that is really messed up. It's from a fair trial judicial standpoint, that is just, I don't see it happening. I just don't see that as a possibility. The whole thing with Brennan saying and I put this in the podcast episode too. This is part of when I started, my snark got a little bit out of control. When Brennan was like, well, I've given them time to hire another one. Shut up. Who cares? Like, what do you mean you've allowed them to? Go sit down. No, they don't have to get another one. They have an independent third party that is saying, hey, bro, this doesn't add up. You don't have to go get another one. These are like the best experts for them. Hearing the juror interview where they're talking about having ambiguity about where the experts came from or why they were, that's a problem. I think that it's good feedback to know that that's a problem. So hopefully they'll be able to work around that this time. I did read something that there may be, don't quote me on this because I've not looked it up. I've just had it sent to me. There's somebody that sent me some stuff saying that there may be something in the next trial to where, like, some kind of new ruling where you're allowed to have, the jury's allowed to know that there's federal investigation or something, but I haven't had a chance to look into that. So if you know more than I do about it, go ahead. But yeah. Yes, the Arca contract ended in June with the feds, but their contract ending with them doesn't mean that now they get to just go talk to anybody and Brandon saying, well, if you want to. No idea what just happened. What is happening to my computer right now? What is happening? Everything is going crazy. Ah! Alien attack. Okay, hold on. What is happening?
All right, I was told counsel wanted to see me at sidebar.
Briefly, Judge.
I have no idea what's happening. Can y'all hear me? Sidebar. I don't know why you can't see. I have no idea. No clue. No clue what's happening right now.
All right, so what I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at mass court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Good morning again, Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night.
Okay.
And on behalf of Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the date you
They'll
said?
have it on or before March 1st.
Okay. All right, so that motion is allowed by agreement, and the order is right here, Mr. Clerk. All right. Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay. All right. So paper number 483. This is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number? Okay.
I'm sorry, the opposition to.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument, and you can give me that.
506.
Great, thank you.
That's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
All right, this is for the forensically sound video, like metadata and all that.
My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions
meeting with Mr. Brennan after court, the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was a download from some iCloud account, unnamed iCloud account. As long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan, and it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that in fact it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that because we would think that in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible.
That was
bullshit. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it, we want it, and now we're asking for the court to order it. I'll submit.
Mr. Brennan.
Just wrought upon the defense that accurate. I no longer
I'm having all kinds of computer issues. It just froze. Did y'all
have
hear?
the confidence to have off
Let
the
me
record
start it back
agreements
from where he
with the
gets up
defense.
there.
There has to be a certain left out of the presentation.
Trial, we want to be as transparent. I'll submit.
Mr. Brennan.
I don't know what's happening. I'm going back to when Brennan started.
It seems like another effort to portray some type of injustice wrought upon the defense that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later? And after they filed a motion making representations that weren't accurate, I no longer have the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process, and I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are...
Okay, first of all, him talking about professional courtesy is a freaking joke. I want to be clear on this. He keeps saying that Yannetti didn't file a motion. Yannetti put in the motion, the preservation request, he put all physical evidence. Videos are physical evidence. That includes physical evidence. And even if Yannetti didn't file that motion, it doesn't matter. That is physical evidence. That should have been preserved. You shouldn't have to ask a police department to preserve evidence. And all of this new video that's just coming up out of wherever, and it was on an iCloud, and it was on this, and it was on that. That's insanely problematic. So the fact that he's talking about professional courtesy, and I did this, and I don't trust the defense. He's like, it's such a, I need a drink. Continue.
Already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later, so we were happy to do it. And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
How quickly can you do that?
I imagine we could do it one day, but today is, we have it done by the end of the week.
You want to make, I'd be heard briefly,
Yes,
very, very briefly.
take your time.
Thank you. Mr. Brennan's confidence notwithstanding, I don't know what to say about that, pretty immaterial, what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, you know, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want the
October 24th, did that video come with the metadata?
No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, again, I'm no expert, my understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. This is metadata associated with all those things. It's not a hard ask, it's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate. If they want to come, they're invited. If the court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs of what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the videos. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it.
Okay. Thank you very much. All right, Ms. Giannetti, the next one should be fairly quick and simple. The motion for Pro Hac Vice. I asked you before when Mr. Alessi joined us, you have a rather vague good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that. I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel?
That's our buddy. Friend of the channel. We've had him on here before. Betterow.
Thank you, Your Honor.
Okay, the next one's paper.
Maybe her brief.
Yes,
Maybe her brief.
yes, yes.
Oh, God. Why?
So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay.
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case. That there's an ongoing, long-term, implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to Special Attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow, who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage, and I am worried, and I have good reason to be worried, about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses, and this information, if a court order won't protect it, then nothing will. Then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse, and that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney, so I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial, and the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay.
I don't have an objection, but let me just whine for a little while. Not
Ms.
a fan.
Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one, I believe, is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and/or Metro Court. Relatively straightforward, but I'll hear you, Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was
Real quick, I see some of you all asking about this. This is not a big deal. This is just, they just want to amend the thing. Right now, the protection order against Voss's stuff says that only the attorneys can listen. He just wants to add somebody that can transcribe it. So it's not a big deal. This is kind of like a nothing burger. It's just, they can't legally have somebody listen to it to transcribe it for them without that being specified in the protection order.
Sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay. There's no objection to this, is there?
No, Your Honor.
Of course, I'll provide the defense a copy if they want.
Yes. All right, so this is allowed.
Yeah, that one's kind of just a nothing burger.
All right, so the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to Defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today, And today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us, and I would ask that the court take no action on this motion until we've had a chance to view them, and we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested.
Understood.
Okay. All right, so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first, or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses, and that's what we're...
Okay, so real quick, if you didn't listen to the podcast or don't know what this one is, so the defense is asking for the court to reconsider the reciprocal discovery order. So basically, in the first trial, Bev was like, hey, anything y'all are going to do to impeach a witness, you have to turn it over. So what they said in this motion is that by having to turn over the things that they're going to impeach the witnesses on, the Commonwealth then had the opportunity to coach witnesses on how to prevent that. So one of the examples they gave was, remember when we were watching Jen McCabe on the stand, and Jen McCabe had been asked very specifically multiple times about, her interactions with police and when she talked to, police, et cetera, her relationship with any of the officers that were there involved, whatever. Never once did she say anything about Sergeant Lank. So they had her cell phone data and had her location data and were able to see that she had been at Lank's house the day after for about 45 minutes. So they were going to use this data from her phone to impeach her and say, hey, you didn't tell us that you were at Lank's house. Like, this is a problem. So then on cross-examination, when she didn't mention it all during, talking to Lally and all that during direct. So then it gets up there on cross-examination, and he asks a very open-ended question about, did anything significant happen that day? And then all of a sudden she's like, oh yeah, well, we stopped by Lank's house because, Carrie's friends with the wife and this and this and this. And I didn't go in. Well, maybe I just went in to use the bathroom. So it's kind of like, all of a sudden, here's this very open-ended question, and now here you are saying this on cross-examination, something that you knew they were going to impeach you for, and he's saying that Lally had the opportunity to coach the witnesses in order to prevent them from being called out for impeachment or lying or whatever. Now, I have personally, maybe I'm wrong, I don't ever remember seeing another trial where you had to turn this over. Like, if you're going to bust somebody lying on the stand, then there are rules to that. There are specific, like, they call it improper impeachment and stuff like that. There are rules on how to do it, or like guidelines on how to do it. But having to turn over, like, and tell the court, ahead of time, like, hey, this is what we're going to impeach them on or whatever. It's a problem for this exact reason. So I know that, turning over discovery is one thing, turning over things that you're like, all of the information is going to get to everybody, like, what you can use to impeach them, but to actually have to be very specific about it, to be to the point where now Jen McCabe is in her meeting with Lally before the trial, and Lally asks her about this, brings it up, and now she knows that she's going to be impeached on it, so now she brings it up on cross-examination. That's a bigger issue. So now they're asking for the court to reconsider that reciprocal discovery order and not have to do that because of this exact thing happening again.
Asking the court to reconsider. It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to Ms. McCabe, it was never mentioned anywhere that she spent an hour at the home, the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data which revealed that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. And secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. And, I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed, so I take responsibility for everything that's in there. But, we also make the point that with regard to, Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument, and he obviously uses derogatory language toward him as well. If we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but this is I won't say unique trial, but it's a rare trial that is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with, and to the extent that we turn over this impeachment material and the Commonwealth uses it, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth's motion for sanctions.
You know what, let's wait. When I said both, I thought you made 2 points that you made both too.
Understood, understood.
All right, so, Mr. Brennan?
Oh, here we go. Self-righteous bullshit.
The court should enforce reciprocal discovery. You should enforce it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice.
Can we just talk about how funny it is that he's talking about trial by ambush and the defense handing over stuff to... Did you not give us inverted Sallyport video halfway through trial? Carry on.
A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody...
Side note, when he says that, do you not want to go A1A, Detroit Avenue? Every time he says A1A, I just... Carry on.
If they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense. Because it's in my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides. And that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it'll be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jen McCabe, or Jennifer McCabe, I should say, revealing this length meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery comes into trial, and I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right, thank you. Next is paper 495. This is
next.
defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed a motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with...
So you have the Commonwealth's response, right?
Yes,
Where it doesn't object to some. Are you going to skip over those? Or?
Yes, of course,
Okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if it's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State Police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos. But that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to
Alessia's showing her
memorialize
something.
material and
You see
relevant
that?
evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
What's he showing her? He's showing her something on the iPad.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There's certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper, Garino. Lieutenant Brian Tully. Trooper, Kathleen Prince. And Norfolk County District Attorney, Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically, in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it?
Okay, and I love her. I love Miss Little. However, I do want to correct one thing. Those texts do not just that he had sex with her when she was a minor. That is rape. That is sexual assault on a minor. You cannot have consensual, and I know that she's not saying it's consensual because obviously the whole thing is she's pointing it out, but she's in court, so she's saying this in a easier to digest way, but those texts show that it was not just sex. I just want to be clear with that. She was a victim of not only murder, but of grooming, statutory rape, and sexual assault.
Relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right, if somebody can tell us the paper number so we can find that.
Thank you, Your Honor, I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the Arca experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor.
That's funny, I don't care who you are.
We'd ask that that be allowed.
Okay.
Thank you.
All right, Mr. Brennan.
Oh, God, I'm already annoyed again. He hasn't even got up there. All right.
It's important to represent facts accurately.
Oh, God.
And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to.
Do we not see that it's a problem when you're like, if there was a chain of custody, they would get that information? Is this another? This is another one of like the, sir, it's your effing job. You don't get to just bring something out of nowhere and turn it in with no chain of custody and use it in a murder trial. If you're using something as evidence, it needs a chain of custody. You can't just get an anonymous email and turn it in as evidence. Oh, wait, he did that. Never mind. Hold on. Let me use another example. You can't just get... No, wait, yep, he's done all of that, hasn't he? So yeah, forget that. Let me rephrase. You're not supposed to just get random shit out of nowhere and turn it in. If it's evidence, there has to be some kind of chain of custody. There has to be some kind of chain of custody. So to say, oh, here's all these random clips that we just found. Here you go. Where the hell did it come from? If you don't know that, that's a problem. I don't know how you, okay, let's pretend, because he likes to pretend, so we will too. Let's pretend like Brennan was on the defense side of this. He's a defense attorney, normally. He's been a prosecutor before, but he's normally a defense attorney now, right? If the prosecution was trying to do, in a case where he's the defense attorney, what he's trying to do now to this defense, he would have the same issues. This is not, this is not groundbreaking stuff. This is not like off the wall. I can't believe the defense is asking for this. If you are being handed clips of videos after there's been an order from the court not last year was the trial. There was an order from the court in, I think, November of 2022. If I remember right, I have to look it up. Don't quote me directly. I believe it was sometime around then, November of 2022-ish. There was an order from the court for all video to be turned over. I'm pretty sure that one had metadata with it too. Anyway, there was an order for that. So then you come in right before trial and you're like, oh, I found a clip. Here you go. And then you come in during trial. Oh, I found a clip. Here you go. And then you come in months after the trial. Oh, I found a clip. Here you go. And then you're like shocked and offended that the defense wants to know where the hell it came from. How is this even a thing? How is this even a thing?
But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto.
I'm going to lose my shit. Okay. I'm going to lose my shit. Jesus, get back in my body. Okay. Okay. Let me get myself together. You are putting witnesses on the stand and presenting them to the jury as credible. You are putting Trooper Guarino on the stand. Yes, he just admitted there's no chain of custody. Yes. Yes. And now he's moved on to the Sandra Birchmore thing. He's admitting that there's no chain of custody. And now he's bringing up their request for the unredacted document for the same people who are involved in the Sandra Birchmore case. You are putting witnesses on the stand like Trooper Guarino, and you are presenting them as credible witnesses who are members of law enforcement and the Commonwealth's, district attorney's office, prosecutions, state police, all these different organizations, right? You are putting them on the stand and having them talk to the jury and telling the jury that they are credible witnesses so that the jury will trust what they're saying, because we automatically want to trust what law enforcement and prosecution is saying, right? Like they have rules, they have laws, they have things that they have to follow. So we want to be able to believe what they say. To say that the defense is wanting to parasite onto this case is bullshit. You cannot put these same people on the stand without letting the jury know how much they can trust them. If you have Trooper Guarino, because remember, a lot of this stuff has come out since the end of trial. You cannot put Trooper Guarino on the stand and be like, hey, jurors, here's a member of our law enforcement, decorated dude, right? Trust him. Listen to what he has to say about this phone data. And not expect the defense to be like, oh, really? He's credible? You want to listen to him about phone data? How about because of him? Not only because of him. He was a major part of the investigation that let this dude who, was cop who, groomed a child, groomed her to sexually assault her, had a relationship with her when she turned to be an adult too, and then murdered her and her unborn baby. And he was like, looking at that phone data like, no, you're good. Nothing to see here. Carry on. Going about your business. No, we're good. Everything's good here. And then the feds come in, they're like, oh, really, bro? Because here's 30,000 text messages that say otherwise. You can't put somebody like that on the stand and present them as credible when they're obviously not. So this does have a lot to do with Sandra Birchmore's case. Not because the defense is trying to parasite onto that case, but because it's a lot of the same freaking people. And the fact that they have zero credibility based on what they were obviously like, they're huge failures in that case, that presents huge issues for their credibility in this case. And if you don't understand that, you should not be a fucking F-bomb. You should not be a prosecutor. To get up here and pretend like you don't know that matters is disingenuous and slimy. Clip that, trolls.
And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says, nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it is helpful for the defense, so they do. You should reject it outright, Your Honor.
The nerve of this
Number
guy.
5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense, so we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland in Giglio, and most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the Department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth v. Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024, please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty.
It's the audacity for me.
Number 6 and 7, we do not object. Number 8, there is a difference between Arca, and we'll discuss that in more detail when we get to the Arca motion, and expert discovery. We have provided, there is a difference between Arca as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for Arca, and again, I'll delve into that when we talk about our situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right, so I'll take that under advisement. Do you
Not a
have that Rule
fan.
17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're
I-
over 500 at this point, so.
Yes.
All right.
This
All
guy.
right, so next we'll move on to the so-called Arca motion, Commonwealth's motion to exclude employees of Arca, paper 497, and the opposition 505. So, Mr. Brennan?
Here we go.
Sure.
I'm like boiling. I can feel my face is red because I'm angry. Let me mute myself.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an Arca expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information's unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the Arca witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about Arca, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the Arca witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these Arca witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes, absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of Arca, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them. Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question, my fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from Arca to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the Arca witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome Arca.
All right, I'm going to take a recess before the response.
Court, all rise, please.
Had to get all my stuff out before I unmute myself. Okay. Get the Jesus back in me. Dr. Wolf and Dr. Rentschler are very credentialed, like, I mean, they're the crash daddies for a reason, right? They had to come to Massachusetts from Pennsylvania twice, once where they were there for the voir dire, and then once for the actual testimony, right? So they're not going to be like, you know what? Yeah, I'll fly out there and spend all of my time and all of my money to pay for a hotel and pay for flights and do all this and this and this at no cost. That's not like that. That's not a smoking gun at all. As far as them having bias, I think that he thinks that this is probably hitting a lot harder than it is. For the people who don't really like care about truth, they just want, like they're carrying around their, pitchforks and their lanterns, like just wanting somebody's, and by somebody I mean Karen Reed's, like just wanting, wanting her head. they'll take this and run with it. But this is not a smoking gun. The things that, like asking about a, like talking about the, outline of experience and stuff like that. Like, these are things that are typical to talk about before a trial. That's not him, getting all of this information that the prosecution doesn't have access to. Remember when they went into the questioning, AJ has a lot of knowledge when it comes to the physics stuff. His questions were really great because of his extensive knowledge in all of that. He was able to ask, and that's why he was able to do such a great cross-examination of Trooper Paul too. Like, Pirouette Paul didn't know shit about physics, but AJ does. So he got up there and was able to ask great questions. So it's not surprising that he was like, yeah, you asked great questions. That's a nothing burger. It doesn't change the fact that all of this testing was done before Alan Jackson or the defense or anybody else even knew that they existed. Their conclusions came, their reports came before Alan Jackson even knew that they existed. They got all of this from the TUI request. So, yes, the Commonwealth had the exact same opportunity to ask questions. The exact same opportunity. They were allowed to ask whatever they wanted to at the voir dire. They were, they were provided all of the same information, the same report. And he brought up, Beverly saying, I say Beverly like she and I are on a first name basis. But he brings up Judge Cannoni saying that the report was vague. That was the whole reason they did the voir dire, because they were talking about it being vague because it was saying, their conclusions kind of like as a whole, instead of which individual person did which individual testing or was responsible for which part or whatever. They did the voir dire and were able to make that a lot more concise as to who was in charge of what. And they had the three crash daddies or Arca experts or whatever. They ended up only calling two of them, remember? Because they called Dr. Wolf and Dr. Rentschler. The third one they never did call to testify. They had the one that came in and testified about the biomechanical engineer who came in and testified about the injuries that, a person would sustain if a car hit them at that velocity or whatever. And then they had Dr. Wolf, who came in and he was the one who built a cannon. I mean, I guess they all did, but he's the one who told us about the cannon, which was one of my favorite moments of the trial. He's the one who testified mostly about the damage to the car. So they each had their specific part that they were kind of in charge of but they all did their testing together. So, is it making you dizzy? Hold on. Let's see. Is that better? Hide the only fan a little. So yeah, so this is like, I'm getting so frustrated too, because that would have been nice to know. Like, just the hypocrisy of everything that he says is really, really frustrating me. That's going to be, I think, one of the hardest things that I am going to struggle with during this entire trial is the hypocrisy of Brennan. That's really hard to listen to him get up there and act. You know why I think it's triggering me? Because it's just like what the trolls do. They get online. Yeah, hypocritical Hank, exactly. They get online and they pretend to be so offended by things that they're doing to other people. And the hypocrisy is like it just irks me. I cannot stand a hypocrite. If you're going to be a douche, cool, be a douche, but just be like, yep, this is who I am. I will have so much more respect for you than pretending like you're mad at other people who are, you know, doing the same things that you're doing, and you're pretending like you're all high and mighty. I hate that. I hate that. And him doing this is, which makes sense. I mean, look, we already know that he's getting a lot of his stuff off of Twitter. I mean, social media like that. He quoted my interview. So, you know, I guess it's no surprise that he's acting like these people, but it's like, I can literally feel my face getting red, because he just, yes, the epitome of projection, the way it just, oh my gosh, it makes me so frustrated. He's going to be really hard to watch for this long of a time. Free Breezy, remember 21 whole months. I can't watch this trial anywhere else. Oh gosh, it's, what a situation. What a situation. Oh yeah, this is bull butter, as our friend Ricky Watson would say. Oh, Ricky Watson would be so mad right now. He would be so mad right now. It's gross and disingenuous. Yes, it is. And that's hard, because seeing a little bit behind, but I just listened to Brainy's rant. Oh, there will be more to come. Seeing the way that he pretends to be outraged at the defense for doing things, but then he does, like, and the whole, like, they have discovery obligations and trial by ambush. Bro, like, do you not understand what you're even saying right now? Like, look at what the Commonwealth has done. And okay, yes, some of it was not him. I will grant him that. Some of it was Lally or whatever. I get that. But also, you are the Commonwealth, so you are now responsible for everything the Commonwealth has done, because you are the Commonwealth. You can't keep referring to yourself as the government and then not expect to take on some of what the government has done. I don't know how. I'm going to get through this long trial with him. I just don't know. We're going to do a lot of drinking and a lot of praying, I feel, in the months of April, May, and June. All right, so him acting like a victim is making me mad. Yeah. A lot of what he's doing is just infuriating. Like, I can, yeah, I can see in the camera my face is red. We may need to bring back Take a Shot to a Squad. Yeah, probably. Because is the second trial expected to be 3 months as well? I don't know exactly how long, but he's talking about all this voluminous, stuff that he turned over, including expert witnesses and reports and stuff. So I'm assuming that he's going to be quite tedious with all of this, and that it's going to be another long trial. Here we go. Let me move myself back again.
Back to session, you may be seated, make sure your cell phone off and put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th. We sent another tour request, 2024. January 6th, we filed our notice of intention to exclude Arca experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the Arca experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact Arca. Obviously, the Commonwealth is in no position to contact Arca because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Here, if I may hand up the discovery that was
Thank you.
provided by the defendant referenced by.
Oh, great, thank you.
Is there any way we should suspend for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we can do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
May I have just a moment?
Yes. Thank you.
This whole thing is a shit show. I want to see what everything said, because if it's, I'm gonna go back and listen to the dates too. The
Your Honor, we'll accommodate the 25th, one way or the other.
All right,
so 25th at 11.
so we'll see everyone.
Your Honor, I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise for the court, please.
So 25th at 11. Yeah, they won't let Alessi do his either. Alessi was going to do the one for Crosby, I think, was the one he was planning on doing today. She said she has grave concerns because of Brennan saying this. So here's my thing. We have heard Brennan, who's very dramatic and whatever. Can't stand him. We've heard him say whatever this is. I wish she would have let oops. Oh, no. I'm about to screw up my computer again. I wish she would have let them respond instead of suspending this for the day, because suspending the rest of the motion until after next week and having the whole grave concern thing, now this is just a precursor to what's about to go down. This case just keeps getting worse and worse. Why didn't defense say anything? She won't let them. She won't let them. She says now she has grave concerns and she wants to suspend for the rest of the day and come back a week from today. Let me add that to my calendar. Do we have... Because the next one wasn't even supposed to be till... Let's see. The motion to dismiss, right? I think it was like March 4th and 5th. Was supposed to be the next one. Hold on. Okay, the 21st is when I have for their motion to dismiss being due, which is Friday, right? And then the Commonwealth's opposition is due the 27th. So now we have 25th at 11. All right, let me add this. Carried. Hearing. Okay. We all have grave concerns. Yeah, she doesn't want to hear anything else from Bev just found out Applebee's discontinued her favorite margarita. Why can't they just argue right now? I wish they could. I don't know why she won't. I want to go back and see exactly what he said about... The thing is, for him saying the stuff that he's reading, I want to go back and read or listen to exactly what he says. But the stuff about him saying, like, in my testimony or whatever, having conversations after the fact isn't yeah, she was breathless. She sounded. My thing is, why now does she have such grave concerns when they should have been concerned? Yeah. I have a meeting that day. I will figure it out and I will rearrange to where I can move it around. She's decided she gets to exclude the Arca experts. I think that she doesn't have grave concern about any of that stuff. Yeah. This is why I don't live stream and I stay behind the scenes, because my mouth would get me into so much trouble. Indy Cindy, member for 21 whole months. 21 member for 21 whole months. Thanks for covering this case. It's a lot. It's a lot to deal with. She's not going to dismiss. No, she will not dismiss. But I think it's important for them to do it. Feds are watching. Sorry, dog's getting rowdy. I was giving students direction. I missed that whole thing. So basically, yeah, we can go back and watch. We can go back and listen to what Brennan says. Brennan reads, and I want to go back. We'll go back and listen to it because I want to hear exactly what he says and the dates, because I was making notes. I was trying to make notes and run chat. I want to hear exactly what he says, the dates. Hold on, let me pull it up. The thing where he was like, shh. He said, if you don't want me to say, that's fine. If you don't want me to say this, that's fine, or whatever. Come on. Hold on. Give me 1 second. My stuff just went crazy again. Okay, here we go. Oh, it's back in the one ear. Here's the entertaining audience part. Okay, hold on. Present. Share screen. Entire screen, audio. Okay.
Impropriety. There is nothing that they have provided about the Birchmore case that will provide.
Well, and this is Birchmore.
Now, that call has not been set up by the defense. Is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion. And we'll
Oh my gosh.
continue.
Okay, I missed this earlier.
To abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between Arca, and we'll discuss that in more detail when we get to the Arca motion, and expert discovery. We have provided, there is a difference between Arca as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different.
And that's still
Motion to exclude employees of Arca, paper 497.
All right,
in
here's the Arca.
opposition,
I want to rehear this.
505. So, Mr. Brennan?
We're about to listen to it again. So Brennan just went through all of his stuff about how, like, he went through the 2 we're going to listen to it again because I want to hear it all again. But he's wanting to have the Arca experts excluded. He says that they're biased for the defense, and he brings up the bill that they sent the defense for $23,000, which, like I said earlier, you know, that to me doesn't really say a whole lot. Like the defense is the one who called him as a witness, so they're not going to just show up for free. The U.S. Attorney's Office isn't going to be like, oh yeah, we'll pay for you to go, you know, here's your hotel money and all that. Like, that's not, you know, so that to me is nothing big. But he reads some of the emails. I want to hear again what he says here. This is, and now Bev is like, oh, I've got grave concerns and we'll come back next week. I can't listen to his whiny voice again at regular speed. We're going to go to 1.25.
Deprive the defense of an expert. Or deprive the defense of an Arca expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement. Whether there's collaboration between one side or the other and that expert witness that they don't know about, they can't ask about. That there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the Arca witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is...
He says that it's because he doesn't have adequate discovery, but then he talks about them being biased and stuff. So he kind of goes through two different arguments here.
The proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about Arca, and it was represented these.
Okay, we heard this part.
Some familiarity.
I mean, we
with the
heard it all,
federal
but
government.
you know what I mean.
It seemed to me, based on my limited experience, there was much more to the story. So I called the federal government, and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been to the last trial and reading the transcripts, I only have a flavor for the last trial.
A flavor.
So there is email correspondence between the defense, not only the federal government, but the Arca witnesses themselves. A recent request for their appearance, pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these Arca witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements, or payment. They relied on a reciprocal discovery order of this court for that.
So he's saying the retainer as required. So let me mark this time down too. Hold on. 1:20:00. 1. So I make my notes for the podcast and then have to go back and listen when I'm not trying to talk to all y'all too, so I can get everything. So he's saying when he mentioned the retainer as required, and he said that he's relying on the reciprocal discovery. So then he talks about the 23,000. Obviously, that's going to be anything that's going to be paid to anybody is going to be itemized. So they would know that. This is not going to be like a, oh my gosh, can't believe this is happening thing.
That information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we receive additional information from their office regarding how our involvement will move forward.
Okay, the U.S. Attorney's Office asked, okay, so at this point, they're wanting to, they're talking about, which AJ said in that June 10th, whatever that he was talking about, he said that they had talked about the, he had talked to the Arca experts about like scheduling and background or whatever it was, however he said it.
Now, it's not the opinion that troubles me, it's the relationship, and Commonwealth should have an even playing field.
Even playing field.
Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
So him saying, please feel, blah, blah, blah. Gosh, I cannot talk. Him saying, feel free to make whatever changes necessary. I want to hear what other context that is in. Obviously, I don't trust anything Brennan says or the way that he says things because he has misrepresented so many things. So I wish she would have let the defense respond to all of this.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth.
An outline, hold on, I want to hear that again. An outline for the questions, is that what he said? Hold on, let me rewind that.
An outline of reciprocal discovery. This is information provided by the federal government after numerous requests, chilly requests, and an insistent the best I can to get as much information as I can. We then are provided an outline of questions and answers for a direct examination.
Sorry, Luce.
The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says,
you see how snarky he is? Like this fair-minded objective witness who knows absolutely no one. He keeps doing that. He's so dramatic with all of this, and I don't, and he's misrepresented so many things that I don't trust anything he's saying. Or the context he's saying it in, I should say.
Not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of Arca, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments.
Okay, but how is that? Okay. Help me out here, guys. How does that matter in this case? Because the lighting didn't they talk about lighting when they testified, or am I remembering that wrong? I could be totally wrong. But what does the lighting matter? Because their whole thing was the car didn't, hit him and he didn't get hit by the car.
If you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from Arca to the defense for $23,925. That's not Trimble. That's not
I thought
child
so.
That's getting duped.
It's kind of a moot point,
I
so
didn't know any of this.
I haven't gone and looked at.
I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. I don't care if the Arca witnesses testify at trial.
Bullshit.
I don't care about their opinions. But
Bullshit.
I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome Arca.
All right, I'm going to take a recess before the response.
Court, all rise, please.
About when the conversations happened. Yeah, yeah, he's saying that Arca has picked the defense's side and that they're biased. Oh, no, the Commonwealth has hid a ton of stuff. A ton of stuff. Yeah, she said the Commonwealth provided her with information that causes grave concern. That's a good point. Lally said in court that Arca agreed with the prosecutor. Yeah, it was like he said like what did he say? Like 95% of the TUI material like supported what they said or something. And she recessed instead of letting the defense speak on this. So Commonwealth's motto, nothing to see here. The thing is, Alan Jackson is a very experienced attorney. You can't convince me that he would have done anything that could jeopardize his, you know, his ability to be an attorney. Brennan just accused AJ of lying. It's about to get real wild for Brennan. It would be bad if Jackson lied about never having talked to the Arca guys and not having paid them while leaning on opposite facts in trial, but we never got to hear the other side. To be continued. Yeah, I mean, but there's a difference in covering the cost of what it takes to retain them as, you know, witnesses in a trial and actually paying them to do what they did. Remember, they did all of their investigation and all of their testing and all of their stuff. They did all of that before Alan Jackson even knew who they were. So the way that he's wording things, I wish she would have just let the damn hearing keep going because I want to hear the rest of the argument. Because the way that he worded things, he's making it sound like the defense paid them for what they did. The defense didn't even know who they were until they got the TUI materials. So after the break, Brennan changed his stance on the info he provided and where he got it. Oh yeah, let's go back to that part. Hold on. Let's do that. I want to hear that list he gave of oh, let me pull it up. I want to go back. We'll play that in 1 second. I want to hear that list he gives real quick. Share screen. I want to hear that list he gives of who he got from what.
Will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can
Less than a minute. The chronology is December 4th. We sent another tour request, 2024. January 6th, we filed our notice of intention to exclude Arca experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the Arca experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13, 2025.
Okay, the defense provided the emails.
I think I said the federal government. It was the defense. February 13th.
So the defense provided those emails. I don't know why I'm having so many issues today. So many issues today. Okay. All right. So yes, he changed what he said. He said the defense, not the federal government. The defense is the one who provided him with those emails. So obviously the defense knew what was going to be read because they're the ones that provided him those emails. Hold on, I gotta turn on the fan. I've done got hot. Okay. All right. So obviously the defense knew what was going to be in the emails. So this is not like a, oh, hey, busted, we got your emails thing. The defense is the one that's provided them. Send back 33 member for 15 whole months. Looking beautiful, Brady. Thank you. When I'm actually here, I keep getting kicked off. Don't know why. Actually, that happened a couple times to Mizzy earlier today too, when she was on StreamYard. So I wonder if it's like a StreamYard issue. Maybe I'm mad at my computer for no reason. Anyway, okay, so if the defense provided the emails, they aren't afraid of this. Yeah, I don't know. Yeah, it's hot in here. If the defense provided these emails to them, then they already know what was in them. So this reaction, who freaking knows? Okay, let me pull up. You said you wanted to see Jackson. I'll pull that up for you. If I can get my StreamYard to work. All right, let's see. What was it on? The ones who wanted to see AJ. What was it on? Yeah, troll fuel. I know. I could like, but think about some of the things that they've made a big deal about. What was it? What was he saying it on? Did I lose y'all again? Oh no, wait, I think I'm on there still. I'm so in shock. I don't understand her lack of emotion, then rapidly going off the edge. Trolls on X are horrific. Saw one post calling out all blondes who support Karen Reed. Brandy was mentioned. How pathetic of a life must you have for that to be like the kind of stuff that you want to spend your time talking about, you know? God bless them. Oh, God bless them. I don't see the interview. I see where Christina Rex said that she asked I think they're going to try to take AJ off the case. They're scared of AJ. Christina Rex is the one who asked, but did somebody say there was a video? Or just her? Because I see her Twitter thing. She said, I asked Alan Jackson outside of court if he paid Arca experts to testify at trial number 1. Quote, no, of course not, end quote. He said, in court, prosecutor Hank Brennan read documents including an alleged bill from Arca to the defense for $23,925. That's getting duped, he told the judge. She's going to say Alan Jackson's agreement with God. She's going to try to revoke his pro hoc vice. Yeah, I don't see a video of it. Karen should be happy the jury came back as hung from the jurors' interview. They approached deliberations like a game of Clue with what ifs, not looking at facts, which was very scary. Listening to that was very scary. I think that there needs to be more instruction on specifically what they make sure they understand what they're supposed to be focused on and what they're not. Yeah, I looked. I don't see a video of it, but I do see her text, or not her text, her tweet saying what she said. But it's interesting that he you know, he says, Hank pulled a fast one since he said he got the info from the defense. Yeah, it's interesting that he says that they like he got that turnover from the federal government, and then all of a sudden Bev is verklempt and calls the day, and then he's like, oh, well, I said the federal government, but what I had meant to say. I wish she would have just kept it going. I really wanted to hear what else was said, because let's teach them what reasonable doubt means. That's important. Am I hearing that Bev is going to try to get rid of... I was just saying that. That's just me speculating. That's not like... I didn't say that. I just... Because she said something about how she has grave concerns with what the Commonwealth just handed her, which is obviously what the defense handed them, according to him, when he corrected himself. But she has grave concerns about that and about the defense. So that's just me speculating. So... Bev's reaction was really odd, especially as we watched her response to Proctor and all the other nonsense. Yeah. Yeah, you could tell that AJ looked mad. I wonder if they said anything outside of court after. The only thing that I saw on here was that they said that AJ said he did not pay the... Oh, my phone's blowing up. Phone's blowing up. So also, Karen Reed took the double jeopardy. I cannot talk today, y'all. Took the double jeopardy challenge to toss the murder charge against her to federal court, filing a habeas corpus claim with the U.S. District Court in Boston. The federal filing... Sorry, phone's blowing up. The federal filing comes on the same day Reed is at Norfolk Superior Court in Dedham for a motions hearing that was supposed to include her team's latest motion to dismiss the case. Instead, the hearing ended suddenly and dramatically, with the judge saying that the prosecution's presentation on behavior with witnesses in the last trial profoundly affects the defense team. That's why I said that I think that she's going to try to get rid of AJ. The sides will reconvene at 11 on the 25th. All right, so Reed is charged with, we already know. Okay, in the federal filing, Reed is asking the court to issue a writ of habeas corpus and rule that Miss Reed's re-prosecution on counts 1 and 3 would violate her double jeopardy rights. I am claiming that my April 2025 retrial violates my federal double jeopardy rights. Reed writes in the federal petition. Reed has filed a petition against Norfolk County Superior Court and the Massachusetts Attorney General. This comes after the Massachusetts Supreme Court issued a decision last week finding that Reed's pending retrial on the charges did not violate her rights against double jeopardy. So, I feel like I'm going to throw it because of how many hoops Karen's going through. Could you imagine being Karen Reed and hearing that juror on that interview with Turtle Boy saying, yeah, we all agreed. 12 of us, 12 jurors all agreed that she was not guilty of murder. And her going through a second murder trial, hearing them say that. Could you imagine with that? I can't. I can't imagine. I'm curious to see what her big reaction is, because she's saying it's because of the stuff that the Commonwealth just turned over, but the defense turned that over to them. So her reaction is this whole thing is a shit show. AJ is too smart to do something to jeopardize this trial, especially as many eyes as he knows are on this. He knows that every single thing that happens in this trial has a magnifying glass on it with the world watching. So I could be wrong. I've been wrong before, I'm sure, at some point in my life. Not that I can recall. But I don't think that an attorney as smart as he is would risk doing something to put his career on the line, especially doing something, you know, like that's a provable thing that, like, that's an easy way to get busted doing something. So yeah, they filed an appeal to the federal court this AM. That's what I was just reading, the ask for the writ of habeas corpus. Why would the Commonwealth not just drop that charge themselves? This goes to show, because their pride, because they're wanting to stand on what they said, because they're hoping to prove a point. They're not going to back down because now everybody knows that they're fucking morons, and they're like hoping to save some face and do something that's going to make them not look like the morons that they are, that we've already seen them to be. Hank misrepresented. Hank misrepresents a lot of things. A lot of things. Yeah, after Brad's break, Brennan told... Yeah, and see, that's the thing, is like he didn't correct himself on that until after she was like, I have grave concerns and we all need to go. Okay, and then he's like, oh, by the way... my bad, bruh. This is what was actually, this is what actually happened. Thank you very much. The last one took me forever. Going through all those motions. I felt like I was never going to finish it. Yeah, he was like, oops, my bad. I said the defense. I mean, I said the feds, but it was actually the defense who handed me this. I tend to think the DA is corrupt given this case and the Birchmore case. Yeah, me too. Me too. I just think that everything that they do just needs to have like disinfectant and sunlight all over it, because it's a shit show. The motion to dismiss is due on Friday, and the response from the Commonwealth is due next week. She just blindly accepts his statements. How embarrassing will that be if, if that's what all this was about? It's a very easy thing to prove. So, Ray, that's not fair now because they didn't let these motions play out today. Yeah. Maybe Arca is biased because they factually know Jo was not hit by a vehicle. I think that the whole thing about them being biased is he's kind of like, he's like, oh, yeah, I'm not worried about their testimony. You know, I'm not worried about their opinions. But also then he says, you know, that they're biased and they've said that it's, you know, Rule 14 and they've said that there's, you know, this and this and this. He's like, oh, I don't care. I'm not worried about what they have to say. But then he comes up with all these different reasons why he's worried about what they have to say. How are they going to appropriately do their motion to dismiss? The whole thing is a shit show. Hold on. Let me take the dogs out real quick. Give me like 5 minutes. Let me take the dogs out real quick and then I'll be right back. Okay. Sorry. Because they're like going nuts right now. I'm going to put this on here. Oops. All right. Give me 1 minute. Okay, sorry. I had dogs going crazy. Okay, so now they're back to being lazy little lumps. No offense, sorry. All right, so what we're gonna do, I've got a meeting a week from today that I'm about to try right now to reschedule so that we can make sure that we are here for this. I am really curious to see what happens, and I'm going to be watching the docket to see what comes out, what's ruled, what's whatever. Like I said before, I don't know what else is in those emails, but I know that the defense turned them over, which means whatever was turned over, the defense obviously already knew it was there. I think that Brennan saying when he's first reading this, that the defense or that the feds turned this over does make it look worse. Because that's like, oh, the feds had to give us this, but the defense didn't. And then the way he does everything, the way he misrepresents stuff or whatever, it makes it sound like it's something it's not. So I'm interested to see how much of her reaction is from him saying that part, because to me, that's like the worst of it. Yeah, Microdot said the bill was for expenses only, not for testifying. Yeah, that's the same thing I said earlier today. As soon as he said that, I was like, that doesn't, obviously they're not going to pay out of their own pocket to fly out to Massachusetts twice, spend the entire day on the stand, pay for their own hotel, all that stuff. So that's not, that's not surprising at all. You're not going to have any expert, regardless of being third party or independent or, hired by you or anything. You're not going to have any expert that's going to pay out of their own pocket to fly out of state twice, stay at a hotel, do all this stuff, spend all their time, take the time to have to do these reports and these, put together the outline of their qualifications, etc. You're not going to have anybody that's going to be like, yeah, cool. No, I'll don't worry about it. I got you. I'll cover my own expenses. That to me is like a nothing burger. I am also interested to hear what the defense has to say about it. I think that it's bullshit that she called the, hearing before we got to hear them. So, the whole thing is just absurd. I'll apply there free. Please let me testify. I won't charge a dime. Right? I know. I say we wouldn't, but those of us who feel passionate about this and about what's been done would definitely do it for free. But a third party independent, wouldn't. But also, I keep going back to the fact that they didn't even know that Arca had done this report or what was on the report or anything until after the 2A request. So to say that they paid them, like to insinuate that they paid them for their testimony or that, something like that was done, that just doesn't make sense. So, I need to go watch the voir dire of Arca. Yeah. I mean, I rewatched it, last week because I was having to put all of that stuff in for the, I put all that stuff in the podcast episode when I saw his motion to exclude. So I just rewatched all of that, and I can't remember exactly what he said. He said, I think Brennan read it again at the start. He said he talked to them for like scheduling and background. What did he say? was it scheduling and background or something like that? Basically, like the only stuff you're allowed to talk to them about. You can't talk to them about their testing or their results or what they did or anything like that. It's only like the very basic stuff. So after this case, nobody will trust the court system again ever, especially in Massachusetts. Especially in Massachusetts. Yeah, the feds hired Arca. Had a contract with them. So to insinuate otherwise is wrong. But anyway, what was the 23,000 Brennan was talking about today? I'm assuming it's the expenses that it costs. Like I said, the expenses that it costs for them to actually fly out there, pay for the hotel for them to come out. Because remember, they had to come out twice. They had to come out once for the testimony and once for the voir dire. So, you know, that cost money. 2 experts to come, you know, come out there and do all that. So anyway, I am going to download the transcript from today and get all of those dates together. I will put all of those dates on the timeline. If y'all don't have the link, let me pull it up. If you don't have the link to the Karen Reed trial thing that I have, I put every single date and time that I have on there, and I continuously update it. So I will if I can get it pulled up. I think my computer's about to start going crazy again. Please don't go crazy. Please don't go crazy. Please don't break on me again. Please don't kick me off again. Please don't kick me off again. Anti-camera people are on X having a meltdown. Yeah, I'm not even surprised. And you know what's funny though? Here's a link. I'm gonna put the link in here. This has all of the timeline stuff in there. So you know what's funny though is like they'll focus on what was said that was wrong, but not say anything about the correction. Why couldn't they do court tomorrow? Well, because they would rather spread it out for a week so that it costs more money to fly back out there. Duh. Draining the piggy bank. Draining the piggy bank. I will have all of this in the episode for this week. If you have not listened to the podcast episode, please listen to it. The episodes take a long time. They take a lot of work to put together, but they go over everything a lot more in detail. Y'all know how my ADHD works, and y'all know that as much as I love being live with y'all, my brain doesn't. I have trolls all the time making fun of me because I stop sentences and I can't, my brain doesn't function like that. Can't help it. ADHD. It's who I am as a person. But all of the information that I put together, that's why I do my timelines and stuff, because I have to have everything visually in front of me and put it all together so that I can piece it together, get the full story, and then I'll put it together in that. So check those out. This is going to be a spicy episode of Calm Down, Canton. I need to change the name of that podcast, don't I? To Calm Down, Canton. Calm down. Yeah. Oh yeah, go subscribe to 80s. Go subscribe to 80s. Yes. So I'm about to stop right now. We're going to call it a day for today. I'm going to go ahead and start trying to rearrange my schedule for next week so that we can be here. And then I am going to get together the stuff for the episode. I had planned on there being a lot more on the episode because we had a lot more motions to cover today, but that actually works out better for me that they're pushing some of it back next week because I still have Karen Reed's interview and the juror interview that I'm going to be putting on this episode as well. And then I'm going to go back down. I'm going to put all of those dates together, put all of this stuff together, find all the information I can about it, and we'll break that down in this week's episode as well, too. So make sure you look for that. The next date is 1 week from today that we'll be back in court. Now, the motion to dismiss is due on Friday. So as soon as I get my hands on that, we can go over that as well. Maybe we'll do a live stream to go over that as well, depending on when it comes out. If it, or when I can get my hands on it. It's due Friday, but we'll see when I can get my hands on it. If any of y'all get your hands on it before I do, feel free to email it to me. But we'll go over that. And then, yeah, she's definitely not going to dismiss it. She ain't doing that. But it's important for them to actually go through the process of, filing this and, everything being on the record. So, so I will have the Karen Reed interview, the juror interview, the federal filing from this morning, and then everything that happened today. I will have all of that on this week's episode. It should be out probably Thursday or Friday. What's today, Tuesday? Yeah, so probably Thursday or Friday. And we'll get everything put all together on there. And then I'll get those dates and everything added to the timeline. Sound good? All right, who can I, let me, before we go, I'll redirect you. I'll portal you over. Yep, that's the one from this morning. Content. Yeah, the federal court has the power. If anybody can do it, the feds can, but I've just honestly lost a lot of faith in how all of this has been done, It's really scary, honestly. It's really scary. All right. I'm going to send you over to, we'll go to RA. We'll send you over to RA. He's doing Rose Petal murder trial. So we'll do that. And I'm going to start getting everything together for this week's episode. So there will be a big breakdown of all of this and all the stuff that's happened and all the nonsense and some of the new filings. I'm about to go take some Tylenol, headache medicine. I'm doing that first before anything else. All right, so I appreciate all of y'all. Please hit the like button if you haven't yet. If you haven't subscribed, subscribe so that you can hang out and talk to us. I'll get my schedule cleared for next week, and we'll be right back here 1 week from today. Queen said, I'm on RA on another tab, so I will see y'all over there. All right. I appreciate y'all. I will see y'all soon. This is going to be a heck of an episode this week, so check it out. All right. Love y'all.